Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about dangerous offender applications. Cases that should have gone to the Supreme Court of Canada, but didn't. Nicholas Wong was involved in a shooting incident as a result of an alleged drug deal gone wrong. And in the course of the investigation and the trial, he was charged with and then convicted of discharging a firearm with intent and attempted murder. After the trial, the Crown made an application for Mr. Wong to be declared a dangerous offender. And although he had never been convicted of a firearms-related offense before, the Crown pointed to a prolonged pattern of what it called aggressive or violent conduct on Mr. Wong's part, escalating to the point of the attempted murder and firearms charges that he was facing in that case. And the court had to determine whether or not that pattern of behavior, even though it wasn't related to the specifics of the offense for which he was ultimately convicted, was sufficient to constitute a basis to find Mr. Wong a dangerous offender. He was ultimately found to be a dangerous offender and sentenced to an indeterminate prison sentence. As a result, Mr. Wong appealed and sought leave to the Supreme Court of Canada, who denied the application. And this case is very important. Anytime there's a dangerous offender application, somebody is sentenced to a period of custody that is indeterminate, in that they are going to be in custody forever or if and until they can prove that they are no longer a dangerous offender. And so the significance of this to people across Canada and the significance of relying on a pattern of conduct that deviates from the actual conduct that's before the court should have been addressed by the Supreme Court of Canada. This case essentially opens the door for Crown to rely on much lesser conduct. And as we're having a national conversation about repeat offenders and repeat violent offenders, the ability of the Crown to rely on less violent incidents or less serious incidents to ground a dangerous offender application on the basis of a single conviction for a more dangerous offense or an offense involving firearms opens the door significantly for people to be incarcerated indeterminately across this country on a regular basis. It also opens the door for political positions to be taken, saying that more people should be put in prison for just the rest of their lives or until they can demonstrate they're no longer a risk to public safety, which is inconsistent with the very limited circumstances in which these dangerous offender applications are supposed to be granted by the court. This is meant to be the exception and not the rule, and yet this law creates a situation, or this decision creates a situation in which this may become the rule as opposed to the exception. Unfortunately, the Supreme Court of Canada, I think, failed to see the connection between this larger national conversation that's taking place about public safety and Mr. Wong's specific circumstances. Hopefully, it has another opportunity in the very near future to consider the extent of this and to reconsider whether it will give leave to a case like this. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.